John Marshall, Earl Warren, Oliver Wendell Holmes, Louis Brandeis, famous justices from the U.S. Supreme Court. And now is your chance to put yourself in the shoes of lawyers who argue before the court. Welcome to OCLRE's Moot Court. I'm Tim Callgreen, the OCLRE Program Coordinator. With me is Ben Tracy, staff attorney for Ohio's 10th District Court of Appeals and a member of our Moot Court Case Committee. Ben's here to help us understand what is Moot Court and introduce the 2019 case.
Thanks, Tim. Moot Court is a simulated Supreme Court argument where students get the chance to argue before a panel of real lawyers and judges.
All right, Ben, you just said one sentence, but there's a lot there and I want to break it down a bit. You said that it's a simulated Supreme Court argument, so it's just like I'm going to see on Law & Order, right?
Well, no. Law & Order is trial drama. In trials, you have witnesses, cross-examination, often a jury. Appellate arguments, like those held before the Supreme Court or other courts of appeals, are arguments made to a panel of judges about things that happened in a trial. They're a chance for litigants who may be unhappy with something that happened in the trial to argue that the trial court got it wrong and ask the appellate court, or in this case, the Supreme Court, to correct the error.
All right, so one party to that original trial thinks the court did something wrong and it needs fixed. So they're going to appeal to get it changed or reversed.
Exactly.
Great. So what's this mean for our students that are participating in Moot Court?
Well, it means students in the Moot Court program will be taking on the role of attorneys for both sides of an appellate case and arguing that the Supreme Court should rule in their favor on a particular legal issue. The first step of that journey is going to be for the students to construct a written legal brief.
All right, legal brief. How's that done?
Well, briefs have a formal structure, and a template will be provided to everyone in the Moot Court case file, along with the facts of the case, relevant case law, and relevant statutes. But how to argue the case, that will be up to the students. Good appellate arguments make detailed use of the facts of the case, as well as prior case law, which is known as precedent, and relevant statutes. Students will have to use critical thinking to determine what avenues of argument are the strongest and should be pursued, which are weaker and might be more likely to be abandoned, and how to analogize what happened in the fact pattern we're going to provide them with what happened in prior cases that the court has decided, precedent, to convince the court to rule in their favor.
It's real interesting. So the students are writing their legal brief, so Moot Court's a written competition, right?
Not entirely, or even mostly. The written brief is just the first step. Teams submit brief in advance, writing whichever side of the case seems good to them. But the part of appellate practice that most attorneys relish is oral argument. And on competition day, that's what's going to be awaiting the student teams. Each team will argue their side and the law supporting it to a panel of volunteer attorneys. The volunteer judges will ask questions to clarify points and to press the students' arguments in order to see how well they defend their positions.
Sounds like it's a lot of work, but it can be a lot of fun too. Students really get the chance to get in the shoes of the attorneys and argue before a Supreme Court. They get to know the law, public speaking skills, and critical thinking skills.
Right on.
Great. So obviously this doesn't take place in a vacuum. Tell us what the 2019 case is going to be about.
In a phrase, the 2019 case is about the reach, sometimes controversial, of the Second Amendment.
Yeah, the Second Amendment has been one of the more contentious and controversial amendments recently.
It has. In 2008, the Supreme Court decided a case, District of Columbia v. Heller, which basically ruled that a person has, by virtue of the Second Amendment, the right to possess a loaded gun in their home for purposes of defense. Trouble is, some laws that are already on the books in many states may in some circumstances come into conflict with that. In our case, for example, students are looking at a state law that says you can't have a loaded firearm in your car.
Well, that law makes sense. That's a safety issue.
Sure, but what if your car or vehicle is also your home?
Mind blown.
Well, so this case is about an aspiring high school rocker, Ozzie Mercury, who when he's not touring lives alone in a motorhome he inherited from his mom. He parks it in a little used public road behind an abandoned department store, and he takes advantage of the sewer, water, and electrical hookups there. But since it's not in the best area of town, he bought a pistol for self-defense of his home. One day, he's rocking out, someone bangs on the door, he answers the door gun in hand, only to find that it's the police. He narrowly avoids being shot by the officer, but he doesn't avoid being prosecuted for and convicted of having a loaded firearm in a vehicle, and now he's appealing.
So what's he appealing? It sounds pretty straightforward.
Well, essentially, he's arguing two things. On the one hand, he's arguing, look, this pistol, the characteristics of it, the way I possessed it, where I possessed it, it doesn't actually violate the statute if you read the statute carefully. On the other hand, he's saying, look, even if what I did violate the statute itself as applied to me is unconstitutional. Heller says I can have a loaded pistol in my home for self-defense. That's exactly what I was doing. So how can that be a crime? Students representing the other side will be arguing the opposite. They'll be saying that what he did definitely violated the statute, and that Heller doesn't tell you anything about whether or not you can have a gun in a vehicle. So it's inapplicable.
Okay, so 2 points to argue for each side of the case. They need to show why their side really was the correct side in a combination of the facts and the law.
Students will brief only one side of the case, whichever takes their fancy, but in oral argument, they'll have to argue both sides, alternating each round. Ozzie, for example, will have two attorneys for his side. One attorney will focus on the issue of whether what Ozzie did violated the statute. The other attorney will focus on whether, if what he did violated the statute nonetheless violates the Constitution as applied to him. The state will also have two attorneys. They will each argue one of those same issues, but from the opposite side.
Good argument sounds like can be made on both sides of this case. It's going to be a challenge, but I think the students are going to be rewarded by doing this too.
Tim, that's exactly what we were shooting for.
Great. Thanks, Ben, and thanks for a great primer to the case. I can't wait to see how the court rules in the case of Ozzie Mercury versus State of Buckeye.
Glad to help.
Now's your chance to get going with the case. Go to the OCLRE website at oclre.org to get your case and register your team. Registration is due by March 29th and is limited to only 16 teams. The written briefs are due on April 5th, and the competition is scheduled for April 26th. If you have any questions, feel free to call or email me. My contact information is also available on the website. Good luck. The court will be in session soon.